please the court.
Wait a minute. She's going to set your clock.
May I proceed, Your Honor?
Yes, please.
Good morning. May it please the court. I'm Charles Rankin, and I represent the appellant Daniel Prunty. The primary issue I wish to address today concerns the propriety of the judge's rejection of the effort of defense counsel to exercise a peremptory challenge against juror number 8-8. We've asserted various reasons why we believe the judge was erred in refusing to let him exercise that peremptory. I think the most troubling is taking an overview of the pages of the transcript in which the juror is interviewed. You're left with a number of indications that fully justify the exercise of a peremptory challenge.
Can I ask you this? If we get past the question of whether or not there was a pattern, and we go right to this more substantively, and counsel's asked to justify, and defense counsel says bluntly, let's say, well, the defendant is a white man who has made racist comments. The juror is a black man, and I don't want to have him on the jury because I think he will be biased against my client. Is that okay?
I don't think that's okay.
Okay.
I think that is asserting a reason that is generic to a discrete group.
Even if the defendant is doing that?
I believe that's true. I have to concede that. I mean, you know, when I first read this, I kind of shook my head and said, wow, it can't be the fact that in a killing by a white man accused of killing a black victim that where the defendant is alleged to have made repeated racist remarks, it can't be that the lawyer can't take the juror's race into account in exercising a peremptory. But I think the law is to the contrary in light of Batson and Soares and the case law that's developed. So I think that there has to be something personal to that juror that even if it's related to race, as we tried to draw a distinction in the brief between something that is attributable to a prejudice or a belief about what black people would think or what women would think in a rape case. And here I think we've got that, which I think suggests that Judge Nickerson erred in.
I have to say I'm not that blown away by the reasoning of the defense lawyer here about, I mean, I can understand why the judge would have looked beyond those reasons to what he may very well have thought were the real reasons.
Well, and, you know, if the colloquy had ended after the judge said, well, there's another school teacher, there's two other jurors that have young children, I think that I would be hard-pressed to convince you that the judge had abused his discretion in refusing to let him exercise the peremptory, although I do think that, I mean, we've made an argument that the Curtis mode of analysis that one juror can be a pattern shouldn't be applied to a defendant. Putting that aside, I think if it had stopped at that point, I'd have a hard time saying that it was an abuse of discretion. But I think when you give the lawyer the additional information that the juror, when confronted with the statement that a witness in the case will use the N-word and other derogatory terms, and the potential juror says, wow, and then makes an equivocal, not a firm statement, I think I could be fair, I think that's enough to exercise a peremptory. And then when you go further and you attribute the forthcoming racial derogatory statements to the defendant.
At the defense lawyer's request.
Yes. And the juror at that point says, I've been called those names myself, and gives, again, an equivocal response. I would try. I think those furnish a legitimate basis, not based on race, but based on the personal experiences of this juror.
Doesn't he say, I would be able to do my best on it?
The first time he says, I think I would be able to do that, when asked by Judge Nickerson if he could set that aside. And then he says, I would be able to do my best on it. And I think that, in Long, the court said that an equivocal expression, different than this language, is not good enough. And I suggest that this formulation, the language there, perhaps is not good enough to exercise or require the judge to grant a challenge for cause. But I think here, a lawyer can say, that's not clear enough to me. That's not comfortable enough for me.
Does it make a difference, do you think, that this was the third inquiry? In other words, what you've just quoted from the juror is coming after he's answered two previous sets of questions. And so he's obviously thought about this, in a relative sense, a great deal. And so that the answer about, I will do my best, I think I can, is coming, it's not just reflexive.
That's true, but I think that when you're exercising a peremptory, you're able to take into account how the juror is responding to you. It's not, I think.
But so is the judge able in this context.
Well, I think that Judge Nickerson, in a way, melded the two different questions. Was there cause to excuse the juror, and was there cause to refuse to let the defense lawyer exercise a peremptory? And certainly the judge, and I think that was invited in some respects by the prosecutor's initial challenge using the formulation fair and impartial. There's nothing on the jury form that indicates that this juror won't be fair and impartial. Well, you exercise peremptories for all sorts of reasons against jurors that are not going to be challenged for cause. And I don't think there was a basis, other than taking Judge Link's question at the beginning, to challenge him for cause at that stage, at that early stage. But I think that you're acquiring this information as you go along, and if we're going to let people do peremptories, you have to give them the ability to look at the juror and use whatever information you have.
But this isn't, I don't know the answer to this, but it does seem to me to be somewhat different than just a pure exercise of peremptory, because it's already been challenged, and the judge has said, yes, I think that's a valid challenge, A. B, the judge has rejected the theoretically group-neutral reasons that the defense counsel gave. So it's, as I say, I don't know the answer to it, but it is in a different, you're looking at his exercise of a peremptory challenge in a very different setting than you would be ab initio.
I think the Commonwealth raises an issue as to whether it's appropriate to consider the later responses at all, since the judge initially rejected counsel's effort to peremptorily challenge the juror. And I think that it's in some ways like jury deliberations, where you have an inquiry or interaction with the jury, and the juror, despite being told, don't tell us about your deliberations, says something, says, well, we did in fact consider that or discuss that. You're not supposed to elicit that, the juror's not supposed to say it, but you can't ignore it. And I think the same sort of reasoning applies here. You have to give the judge and counsel leave to consider the entire interchange.
I agree. You can't, once it's said, you cannot ignore it.
I'm curious, were the earlier jurors who were also teachers, were there any questions or issues, discussions about them before they were seated?
I don't believe so, Your Honor. It was just almost as the same as Juror 8-8, where there was group questioning, and then the juror was brought up individually for the racial question, and there was an answer, and the judge declared them to be indifferent. So there wasn't any additional information garnered from the individual voir dire.
So there was no concern raised about the fact that they were school teachers?
Right. I mean, there wasn't, counsel didn't ask the judge to conduct any further inquiry on that basis.
Is it your view that our analysis should be the same regardless of whether it's the defendant or the Commonwealth which is making the peremptory?
Well, I think it has to be different. I mean, I think if we're going to have peremptories, and if we're going to respect the common law basis of the peremptory, which seems to be where it comes from, and you read Blackstone, it developed out of a sensitivity to a defendant being able to get a panel to judge the defendant in a manner that makes him or her comfortable. And so it appears that that's why peremptories developed, and we try to articulate a reason why this one-person pattern shouldn't be applied to a defense challenge of the first minority or female juror.
Right,
but I think
I'm sorry. Finish.
I think that a judge has to be sensitive to a defendant's effort to exercise peremptory, and I think that there has to be a certain sensitivity that the trial judge is not trying to engineer a cross-section jury. And I worry in this case, on this record, that may have been part of the judge's thinking. He, in fact, appoints juror 8-8 as the foreperson of the jury at the end of the case, which is, it makes me worried that that was going on here. I don't know that...
He was a school teacher, so he's used to organizing discussion.
Well, I mean, it's true, you can articulate that, but I think it's, there was a case in federal court, Green, where Judge Gertner tried to expand the veneer that was available to sit in a death-eligible case to include more people in the African-American community who were woefully underrepresented. And the court, the appellate court, which struck down our efforts, expressed real concern about trying to engineer a jury that is something other than randomly chosen.
Let me follow up. Let's assume you have a defendant who says, I just don't feel comfortable having a black man on the jury. I just, especially since there's a black victim here, I just really don't feel comfortable. I want my attorney to exercise peremptories with regard to black jurors. Should we respect that?
I think that's essentially the same question that Justice Link was asking, and I think that we can't do that.
Okay,
We can or we can't?
Cannot. I think the law is to the contrary.
Okay, but you say the analysis should be different when a defendant exercises than when the Commonwealth exercises.
Yes, I do believe that.
More respectful of the choice?
Yes.
But isn't the constitutional analysis with regard to it is because the public has a right to sit on the jury, and which is why that neither side can waive a Batson challenge?
I think that a defendant's right has to be paramount in the three parties at stake: public, private, Commonwealth.
And articulate then what this defendant's right is. Clearly he has a right to a fair and impartial jury, but you seem to say it's something more than that.
I mean, there's a tension between the presumption that a peremptory is exercised properly and the finding of a pattern. And I'm not quite sure what rule to articulate to give the defendant an extra ability to exercise the peremptory free of judicial intrusion. But I do so. Other than what we've proposed in the brief, that a pattern of one cannot be held against the defendant. I mean, the reasoning of those cases has been that the Commonwealth, by striking the first person who is like the defendant to come up for the veneer, is depriving the defendant of something. The same reasoning doesn't apply when it's the Commonwealth challenged a defendant's effort to strike it.
But the problem seems to me that the defendant's right to a peremptory challenge or to use peremptory challenges is not constitutionally based.
That's correct.
It's rule-based. And that rule gives the Commonwealth exactly the same number of peremptory challenges as it does the defendant. And it doesn't distinguish how the Commonwealth shall use them differently than the defendant.
Well, I mean, the way the law of the one person as a pattern developed, it did distinguish it by focusing on the defendant's right to have a person from his own group take part in the jury, or at least that challenge scrutinized. And it was applied by this court once without comment to a defense challenge. And I think that's what I would ask the court to think about and address, whether it's appropriate and prudent to permit the Commonwealth to make a pattern challenge of one.
But does this rule that you're describing, this ancient common law origin, does it predate the 14th Amendment?
Oh, I think Blackstone goes back to the 1500s.
Well, isn't that the answer? I mean, this is a different country. And the 14th Amendment sets a whole different playing field.
I mean, the cases we cited have discussed the common law origin of it in the Supreme Court of the United States.
There's something almost inherently untenable about that position that the government and the judicial system should countenance this kind of different treatment of citizens. I mean, after all, we're all peers in this country.
Well, I think I tried to address that issue with Justice Gantz and Justice Link's question, that I don't think a defendant can strike a juror simply because I don't like African Americans or I don't like women. But if it's a characteristic that's personal to that juror, the personal experiences of that juror, you can. And we gave a couple of examples in the brief, and I think the jurors' reactions here.
But isn't the inquiry that we've created, the formula for inquiring, designed to flush that out? And the judge asked trial counsel for his reasons, and he gave certain reasons, but those reasons did not support or did not provoke a challenge by counsel as to other teachers. And the judge concluded that this was a sham, that essentially it was racially based. Why is the judge wrong about that? And he was right there.
Well, I think that as I said before, if the inquiry had stopped at that point, I don't think I could try to convince you, or I couldn't successfully try to convince you that he had abused his discretion. But when the inquiry continued, I think you've got plenty of basis at that point to step back and say, well, in light of all of this information, counsel does have a legitimate
But
basis.
defense counsel didn't renew his request for a peremptory and say, now, Your Honor, I have new reasons for exercising it.
Well, I mean, the judge's last words understood that this was certainly the defense counsel's argument. I mean, he says, I find that you don't have cause to challenge the juror, and I reject your effort to
But isn't there a difference? The defense counsel uses his peremptory, judge does his analysis, finds it's pretextual based on race, then he calls the juror back. At this point, isn't this purely for cause? I mean...
No. I mean, it's...
Because that was not, basically, this was not a reason given by defense counsel.
Well,
Defense counsel
I mean,
didn't say, I wish to remove him because of, that was not a reason he gave.
That was not an initial reason he gave, but the entire colloquy is, it's not as if the juror was called up in response to the first question that was asked and then sat back down and then came back up in response to another question. This is one continuous discussion, and I don't think the court can fairly parse out and say, okay, after the Batson challenge was rejected, they then went on to discuss cause. I mean, that's not a fair reading of the transcript.
But this is the answer that the juror gave is classically one that is considered in a for cause analysis.
Well, and I know, and I think that's part of the problem, that Judge Nickerson took it in the context of cause when they were discussing both cause and the peremptory. I don't think it's a fair reading of that extended discussion to say this was a cause-based thing. I mean,
Isn't your argument on the second part 2, really that no, it's not cause, but it's what is revealed is not group-wide. It is this, yes, it's based on race, but it's this individual's own personal experience.
yeah, I mean, that we gave an example in the brief.
But that's cause, isn't it? I mean, what you're
No.
saying is that this juror, the answer this juror gave suggests that he cannot be fair and impartial.
Well, no. I mean, take an example that we used in the brief where it's a Commonwealth peremptory, and the witness, an African-American with a white defendant, the juror with African-American with a white defendant says, I've been harassed by the police, I don't like the police, but yes, I can set aside my beliefs and apply the law and the evidence. And the judge finds no cause to excuse the juror in light of that unequivocal response. Can't the the Commonwealth exercise a peremptory against that person, not for cause, not for a race-based reason, but for the juror's expression of a personal hostility towards the police, even though the juror says, I can set this aside?
Do you agree that this juror could not have been excused for cause?
I don't agree with that. I think the juror should have been excused for cause.
Okay.
I do. But I also maintain that that's a closer question, I think, than whether he could have been subject to a peremptory challenge in light of the entire
Rankin, we're
column.
going to have to leave it there.
Thank you very much, Your Honors.
Good morning. May it please the Court. Good morning, Your Honors. Thomas Schack for the Commonwealth. I'm accompanied today by Assistant District Attorney Genevieve Henrique. She's a newly assigned Assistant District Attorney to our Appellate Division with the Cape and Islands District Attorney's Office. Your Honors, the prosecutor's objection to the use of the peremptory challenge was certainly appropriate under the circumstances, and it was brought to the attention of the trial court in the only way that the prosecutor should be able to bring such a challenge or such an objection. The fact is that on the face of the juror sheet, as Judge Nickerson indicated and as the prosecutor indicated, there was nothing out of the ordinary that would raise some initial concern about any kind of potential bias that might exist on the part of the juror 8-8. Now, certainly it would appear that he was the only African-American individual within the Venari who would potentially sit on the jury, and I would suggest to you that Judge Nickerson's analysis was absolutely appropriate. The fact is that when the Commonwealth raised the objection, the trial counsel simply turned and said, this is based upon the fact that, he's a teacher, he's married to an administrator, a school administrator, and in fact he has small children. Obviously and astutely, Judge Nickerson realized immediately in looking at in examining the other jurors that there were several other either retired or active teachers, certainly individuals including one teacher with small children, and a number of other individuals who were sitting in the panel who also had small children. So clearly, based upon the the trial counsel's objection or use of the attempted use of the peremptory, that was certainly, it was reasonable for the judge to determine that that was a mere sham. And I would suggest to you that our position was not that the court should have or could have ignored the additional voir dire that occurred with Juror 88, but that it wasn't necessary. Perhaps out of an abundance of caution, but certainly at the request of trial counsel, the questioning of Juror 88 continued. And that questioning was very detailed and specific with regard to his background. But again, I think it's an interesting note that
I just want to see if I understand what you're saying. Are you saying that if, given the first part, Commonwealth challenges the exercise of the peremptory, judge agrees with the Commonwealth, but then goes on, if the juror had said in the second phase of this something that indicated, that he couldn't be fair, would you say too late, too little, too late? He needs to sit.
no, I would suggest that perhaps I'm not being clear, Justice Botsford, but what I would suggest is that at the initial inquiry of the trial attorney, of the defense counsel, of what his reasons were. Once he said, it's because he's a teacher and because he's married to an administrator and he has small children, that once the court makes the determination, I find that to be, mere sham, then I think that the inquiry could have ended. It didn't, and it certainly has to be, in the further inquiry in the further voir dire has to be considered, certainly.
Okay, all right.
Let's imagine a scenario which happens, although it didn't happen here, I gather. I gather there was no request by the defendant here for inquiry of the jurors in general as to whether or not the use of inflammatory racial language would affect their ability to be fair. He didn't ask.
No.
He didn't ask for each juror to be asked of that.
Yes,
okay.
Justice Gantz. There were no one else was inquired of in this way, and I think that also indicates, again, this is really presupposed bias on the part of Juror 88, which is, again, that is not, I think that is exactly why we have cases like Curtis and why we have, why the progeny of Soares, goes in that direction and suggests that we have to have a fair and impartial system for all, not simply for the defendant. But in this case, certainly the further inquiry, I would argue, is absolutely unequivocal. And it's unequivocal in this respect. The second inquiry that occurs, the juror said, after saying, wow, to the fact that there was going to be some racial epithets used, the court says, yeah, wow, and the juror says, as a teacher, I've always been able to, separate things anyway, so I think I would be able to do that. This comes on the heels of his earlier answer to the first inquiry that all other jurors were asked, whether he could be fair and unbiased. And I would also suggest to you that the trial court, Judge Nickerson in this case, is there. That is why you give discretion to the court, to the trial court. That is why we expect, that jurist is looking into the eyes of the individual and watching their demeanor. And Judge Nickerson goes on, even after this exchange, and puts on the record, or states on the record, specifically his observations regarding the contemplative nature of what the juror, how the juror thought, and he rocked back in his shoes. This wasn't simply some knee-jerk reaction. And compared with the case, that the defendant cites in Long, where there's complete equivocation from beginning to end, this could hardly be described as equivocation.
Now, if the inquiry had been made of this juror before the strikes were made, and if the juror had hesitated when asked the question as to whether the use of the N-word would affect them and paused for a number of seconds and then said, I think I can be fair, would it then be appropriate, do you think, to say, I wish to strike that juror because he hesitated, he didn't seem sure, I can't be confident that he will be fair in view of his apparent hesitancy?
Well, I certainly don't doubt that the trial attorney in this matter would have done that. I don't believe that the strike would have been necessarily appropriate. But I think, again, it's left to the discretion of the trial court. I think the trial court is the one who we have to rely upon to make the determination based, again, upon upon all of the observations in the courtroom and all of the observations of the potential juror. And I think that that's exactly what Judge Nickerson did, and he did an excellent job of creating a record that really took this into consideration. I think it's a very clear record with regard to whether or not this is really equivocation, and there certainly was no equivocation, certainly in the Commonwealth's from the Commonwealth standpoint.
Now, the judge ended by saying, the juror ended to say, I would be able to do my best on it. Judge didn't then follow up and say, I appreciate that you would try to do your best, but are you confident that you would succeed?
Well, and again, I think that's an argument that's raised by the defendant, and I would suggest to you respectfully, Your Honor, that you have the initial response, which is completely unequivocal. He says, no, this would not, in the first exchange, absolutely not. Then when, then the waters are tested, so to speak, with the juror with regard to, specific epithets at the request of the defendant. And then you have the final exchange in which, okay, now the defense counsel is asking that those statements be attributed to the defendant, and we see where the juror goes. What we see what the juror's reaction is. I think that in light of the fact that there was, no equivocation, you cannot extract or you cannot extrapolate that there's any equivocation in the first answer. I would suggest to you that these answers, the second two answers, are simply well thought out responses. Now, there may be some emotion associated with it, but again, Judge Nickerson standing there, or at sidebar in the Barnstable Superior Court, and again, being only a foot or two away from this juror, and seeing his eyes, hearing his tone, making determinations based upon what he says. I don't think that that just taking the plain words as they appear on the page can suggest that this is equivocation. I think that you have to, in this case, give the benefit of the sensory aspects of this case to the court, and I think that that's why it should be largely left to the discretion of the court to make that determination.
Do we take this comment sort of in the context of the other comments that the juror made in response to prior questions? Because I note that at the end of the first sort of go-round, he said, so I think I would be able to do that. And then at the end of the second go-round, he says, I would be able to do my best on it. It's not so very different phrasing.
No, it's not different phrasing, and I think it's the third go-round, Justice Lang.
I'm sorry, the third go-round, second and third.
Yes, Your Honor. The second and third ones are certainly, again, I think based upon the language itself, saying that he can do his best on it, and after hearing what he heard, and after the court puts on the record, his demeanor and how contemplative he was, I think that that's enough. I think that's enough to, and I would suggest to you respectfully that is enough to completely remove any question of equivocation.
If he hadn't done that, but had been, I don't know, I'd try, or something like that. Do you have any view on whether or not that provides, a new basis for exercise of peremptory challenge, even if the judge wouldn't strike it for cause?
I think it's problematic, and I think it's problematic from the standpoint that what this really basically allows, and in this case certainly, if the defendant were to prevail in the argument, it allows a fishing expedition in a sense that in which the defendant is making the request. And he's the one who attempted to engage in the peremptory challenge, and then at the end of all of this, we say, "Oh, now he's disqualified based upon the questioning itself." If he had taking the record as it's before us, I don't think that you have a situation in which you can say that the defendant should then have been entitled to a peremptory based upon those answers.
So does that mean that the judge, though, suppose the answer was more than unequivocal? Was clearly equivocal or worse, saying, well, No, I really just, I wouldn't, that would probably do the trick for me. I couldn't do that. And the judge says, well, but I think you could, and refuses to strike for cause. Are you saying even in that kind of a situation that if the defendant couldn't exercise a peremptory?
No, I think if the language, as you suggested, Justice Lank, was that equivocal, certainly a peremptory challenge would have been appropriate, but it wasn't in this case.
Right.
So again, I would just suggest respectfully that that's not the case. That based upon that that thorough examination and Judge Nickerson's reflections on the record of what he observed of the juror, it's unique. I mean, I think that the record is unique in many respects because of that, because it does show such a contemplative process. And I also would suggest to you respectfully that the suggestion that the Commonwealth should go back to a pattern versus the singular use of a peremptory challenge with a discrete member of the society, of a group within society, I think it just sets us back. I mean, it sets the Commonwealth back years. The Commonwealth's entitled to a fair trial too. I don't think that the defendant it is adequate or appropriate to suggest that the defendant is entitled to, just as Justice Spina pointed out, there are equal amounts of peremptories given to both sides. The Commonwealth's given a voice, the Commonwealth's given an opportunity to be heard, and the Commonwealth should be allowed to try its case just as a defendant should. Certainly, a defendant has rights that have to be addressed and thought of and taken into consideration. I would suggest to you with regard to this issue, that's exactly what happened in this case. I think that I think that Judge Nickerson's approach was appropriate. The actions of the prosecutor were certainly appropriate, and I would suggest that based upon that the peremptory challenge was a mere sham, and that it was properly prevented. If I can move on to the appellant's second argument with regard to the issue of the charge at the end of the case and the suggestion that perjured testimony before a grand jury should be admitted as substantive evidence, I would respectfully suggest that that shouldn't be the rule of law, certainly in the Commonwealth. I don't believe it is. And I would suggest to you respectfully that in this case, the jury had ample evidence before it to suggest that Daniel Prunty, in an angry rage, had gone upstairs in his house, collected a rifle, come downstairs, held it towards the head of Jason Wells and pulled the trigger, killing him.
Can I just ask, though, I know that you said that there was ample evidence of warranting the jury's verdict, but is it true that the testimony in question came in without objection? And so there was no limiting instruction or nothing that suggested it was just coming in as a prior inconsistent statement?
Yes, I think the record does not show any objection.
No objection, okay.
Yes.
So I know you say it's perjured testimony because the witness admitted at trial that she had lied. But she had lied when she said those prior things. But isn't that also something for the jury to evaluate? I mean, isn't the jury free to look at what she said in court and say, well, I believed what she said before, not what she says now?
I think that if there were corroborative evidence, Justice Lank, that might be one thing. If there were corroborative evidence of what she had stated, again, the overwhelming evidence was that the defendant was in the kitchen at the time. That there were other individuals who saw the gun pointed at the head of Jason Wells. They saw the defendant fire the weapon, and again, you have the consistent statements of people who are in the house in other locations who can hear everything.
I appreciate that, but I mean, isn't it conceivable that the jury could have disbelieved all of that and believed? I mean, it's not inconceivable that the jury's always free to believe or disbelieve every witness's testimony.
Certainly, but I think, Justice Lank, with regard to the issue of if there was some other testimony or evidence of some sort that would bolster that earlier testimony, I would say possibly. Possibly.
So what you're saying in response to Justice Lank, I think, is you would theoretically agree that I mean, in the usual case under Day, when grand jury testimony is used, it's that the witness on the stand, from the Commonwealth's perspective, is lying and was telling the truth to the grand jury, right? And so it comes in. And this is the flip.
Yes, Your
correct?
Honor.
So in theory, I think you're agreeing that in theory there is really no difference between those two, but the reason in this case is that that third element isn't there. That is the corroboration.
That is my argument, Justice Botsford, that there should be some indication of some corroborative
But
evidence.
you wouldn't disagree that if there were, if there were, these are, as Justice Link is suggesting, these are the same, I mean, they're just two sides of the same, anyway, they're different sides of the same coin.
I would agree with that, Justice Botsford. And I would also suggest to you that the fact that the lack of any corroborative evidence suggesting the same, takes it out of the realm of the
Having
Day
even to
case.
worry about that.
Yes, Justice Botsford. The fact is, again, that the jury certainly, was able to discern and apparently did discern based upon the facts that were presented or the evidence that was presented in the case, and they discerned the defendant's guilt. Now, with regard, again, specifically to those earlier statements, Pape took the stand. She said, I lied. I lied because the defendant was providing me with drugs. He was my support system in a sense, and that's why I lied. It was a very plausible reason for her engaging apparently in that illegal behavior earlier. But nevertheless, I would suggest to you that that area of the case was well studied. I would also suggest to you respectfully that with regard to the issue of the instruction, that that was a very minor. I mean, in a sense, it's a very minor issue, and so unbelievable in a sense. It's so unbelievable that that he was in a different place, in a different room, at a different time. Again, based
when all these other people are seeing him.
Yes, that it was. It's a minor issue in comparison, and I would suggest to you that in light of that, the Commonwealth's the defendant's argument should fail. And finally, with regard to the 33E relief, I would suggest to you that in your supervisory powers in combing this record, that there is no other source of relief that should be or reason why the defendant should prevail. And I would suggest to you that, as in many cases here in the Commonwealth, this is a case that was tried cleanly. It was appropriately managed and overseen by Judge Nickerson, and I would suggest that the conviction should stand.
This is a factual question I should know. Was there a request for an instruction that the witness's grand jury testimony be admitted substantively?
No. There was some discussion. The prosecutor brought the issue up after the charge. Brought the issue of credibility up. They skirted around the issue of credibility, and Judge Nickerson did turn to trial counsel, as I recall from the transcript, and said, "Is there anything else that you're concerned with regard to this this particular area, this issue?" And as I recall in the transcript, the answer was no, and they moved on to another series of areas that the defense wanted to approach.
All right. Thank you, sir.
Thank you very much.